Good morning, everyone. Chairman Smith, I guess you're here now. I thought I got a note that you wanted to go later, but you're here now, so do you want to? What's easier for you? What's good for you? Oh, I'm sorry. I thought you had something someplace else. First, in subcommittee, you've got 112, right? Okay, so would you prefer to go now? All right, let's do it. Good morning, everyone, and Senator Smith, welcome. We're taking up Senate Bill 439. 439. Yes, sir.
We have a motion.
Are we trying to break some sort of North American record here?
Yes.
Believe me, I've got no problem with that. I just want to ask the question, and I never have from a meeting efficiency standpoint.
Because I think we've about worn out our welcome on this issue after the fourth year in a row on both House and Senate bills.
Reminds me when I was in a meeting that Senator Smith was chairing. I think I said about 2 or 3 words, and Senator Smith said to me, "Good speech," and I've taken that as a good approach since then. I tell you, timing is everything. I just want to make sure that we're.
16.
Okay. We addressed this, and let me just make sure I'm not misstating that we addressed this issue as well in Representative Neal's bill, correct? Are there any? Okay. And so this is a little more expansive. Okay. Okay. And Senator, I'm just we addressed this in a bill that Representative Neal had, which certainly does not preclude our addressing your bill. I just for purposes of my own clarity, just wanted to see if these were identical or not. There are differences, which it doesn't preclude anything, but I just wanted to ask that question. But if you wanted to give us the, your presentation.
Okay, well, it's extremely brief. We've actually passed this bill, I believe, 3 years in a row, over 2 terms. Stopped for various reasons that at this point don't matter. But the purpose of the bill is to bring gender neutrality to the statute dealing with the prosecution of incest, such that in the almost unfathomable situation that unfortunately occurs at times, if you have a stepfather who is committing incest against a stepson, the statute would apply, and under the current code it only applies across lines of gender, and there's never been any opposition to the concept. In fact, what I tried to do with this bill was to adopt the latest version from last year that passed out of this committee, not the Senate committee, on the hopes that maybe it might accelerate things. But I'm completely open to changes. In fact, Jay Neal is going to be the House sponsor of the bill, and he is. I talked to him yesterday, and he actually prefers that we use the Senate bill because he has a number of bills and rules and would prefer not to have to use one of his chips on this if he can use it on something else. So I'm happy to adopt. I haven't seen Jay's language, but I'm happy to adopt if in the wisdom of committee there's a better way to do it.
No, I appreciate your communicating with Representative Neal. That cuts out a lot of logistical problems later on. Questions for the author? Seeing none, Mr. Collins.
Motion to do pass.
There's a motion to do pass Senate Bill 439. It's LC 294152, second by Representative Abrams. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Chairman Smith.
Okay, thank you.
Is Senator Butler here? Senator Butler, we'll call you next. And that's regardless of the fact that you're in my parking spot this morning. But it's not. But it's not an issue, and I will tell you that Representative Peake, who is usually parked next to me, he's on his own. So let me ask you, Senator, if you wouldn't mind coming up. And members of the committee, we heard Senate Bill 4 last year and passed it out of committee. I think it got caught up in the rules process, if I recall. So this is a repeat performance for Senate Bill 4. Senator Butler, thank you for joining us this morning.
Thank you, Mr. Chairman, and thank the members for being here this morning. I did send you one extra sheet on this bill, and that's to show how many protective orders are served in each county in the state. And the total number is close to 24,000 protective orders that are served. But since we heard this last year, nothing has changed. The protective order is for those that are abused in certain situations. And when a protective order is served, we want the person to be notified that it has been served, either by telephone or the newest text or email. But that person has to ask for that service. And once they have asked for that service, we expect that it will be done. And I just ask for another do pass. It passed unanimously, I believe. Maybe a couple of folk didn't.
Let me ask just either counsel, I know, Mr. Bundrick, thank you for filling in for Ms. Travis. We appreciate it, and I don't expect you to know the answer to this. Maybe Ms. Morris. What passed out, and I haven't checked the file, did we do that by committee sub last year, or was it the Senate version? It was a Senate version. Okay. Just to make sure we're dealing with that which we passed out last year. In fact, we are. Questions for the author, Ms. Abrams?
I'd just like to be recognized for a motion at the appropriate time.
Okay. Oh, right, the effective date. Right.
Okay, thank you.
We'd have to go ahead and move that effective date to 2010. We'll do that in the nature of amendment, on the motion.
Jill also sent the comment last night. Travis said that on line 21, there's also recommending changing the word is to shall be.
It's 21.
That little script.
Right. I'm looking at that email for the first time now. That was sent at 9:39 p.m. last night.
Which other line was it?
Sure. All right. We'll look at that in the context of an amendment. Questions for the author, Mr. Hatfield?
This is, for the author or possibly for Mr. Bundrick, but and I'm not sure at all if this is a concern. But what about where civil process servers have been appointed by the court? Would those be affected by this provision, or do they need to be affected by this provision?
Those are private, aren't they?
No, the court can appoint persons to serve civil process, and that goes on quite regularly. So I don't know if that needs to be addressed or not. Just throwing that out there.
Mr. Bondrick, do you have an opinion?
Mr. Chairman, I have not read the bill. I just think it was back this morning. I'm sorry.
Ms. Abrams?
I had a question for Mr. Hatfield, maybe. Would it be that if you have a marshal who's serving, or if you have a civil process server who's serving, because these are obliged by the marshal to serve, even if they hire someone, aren't they essentially agents of the marshal, and the same would still apply?
No, they're actually those persons are appointed by the court, and they're officers of the court at that point in time when they're serving process.
Okay.
So I don't think that they would I don't think they would fall under the powers and duties of constables or marshals as such. I think they're a sort of a separate animal, if you will. That's going to be under Title 9. The civil process service is going to be under Title 9. It'd be under the Civil Practice Act, I believe.
If I may ask a follow-up question, because this is not my area, why would a civil process server be serving a protective order?
I'm not even sure. That's what I was asking legislative counsel. I'm not sure if they can serve it or if they cannot.
I don't
know.
think they can. I think that civil process servers, because protective orders are criminal, I don't think a civil process server would ever be allowed to do that.
Do you know? Okay.
Even in a divorce situation?
But to get a protective order, your protective order is criminal. It's not a
Right.
civil
This
matter.
is a different. It's not a typical domestic relations sort of case.
I mean, this is only with respect to protective orders. It's not with respect to all process servers. So I would think that the issue would actually be a moot one because you wouldn't have. Okay, not today.
Any further questions for the author? Has anyone signed up to speak on? Mr. Bunder, could you slide the clipboard? Bob, thank you. Thank you very much. Kirsten Rambo with the Georgia Commission on Family Violence. Hi. Senator, if you wouldn't mind, if you could slide to your right so we could have the witness come. I would like to stay up here just in case there are any other further questions and we have any issues. Certainly want to get your opinion on them. Ms. Rambo, welcome.
Thank you, Mr. Chairman and members of the committee. I'm Kirsten Rambo with the Georgia Commission on Family Violence, and I can keep this very short and sweet. Just
Thank
wanted
you.
to really thank the sponsor and the co-sponsors for this bill. We think it's a straightforward, great bill, very much needed, and we're fully in support of it, and we appreciate you bringing it.
Questions from Ms. Rambo? Seeing none. Thank you, Ms. Rambo.
Thanks.
Ms. Shelley Centerfit with the Georgia Coalition Against Domestic Violence.
Thank you, Mr. Chairman, members of the committee. I'm Shelley Centerfit on behalf of the Georgia Coalition Against Domestic Violence, the coalition of the domestic violence shelters in Georgia. We, too, are very grateful for this bill and would urge your favorable consideration. I'm also a family lawyer when I'm not down here, so I can address Representative Hatfield's question. I have never had a TPO in which a civil process server has been appointed. The good news is that our sheriffs in the state really prioritize the serving of these orders, and there's no fee. Unlike other civil matters, there's no fee associated with service, and so although I suppose perhaps someone could choose to appoint someone, I don't know why they would, because these orders are typically served within 24 hours given the nature of the proceeding, and so I think that we're covered if we just make this applicable to sheriffs and constables. Thank you.
Any questions for Ms. Centerfit? Seeing none, thank you very much. Mr. Oliver Hunter, General Counsel with the Georgia Sheriff's Association.
Good morning.
Morning,
Oliver
Senator.
Hunter, Sheriff Association. We just want to thank Senator Butler for the bill and to make it clear that she's worked with us. We have no problems with the bill at all, and we're supportive of it.
Thank you.
Thank you.
All right, I see no one else signed up to speak on Senate Bill 4. What's the pleasure of the committee? Ms. Abrams.
I'd like to move to pass Senate Bill 4, SB 4 FA2.
Motion by
We haven't amended it yet.
Representative Abrams of Senate Bill 4, SB 4 FA2, second by Representative Hatfield. Are there any amendments? I'm going to go ahead and propose, my apology. That's Alan Peake calling me.
He voted no.
So, Senator Butler, you'll be getting a call from Mr. Peake as I hand off that issue to you.
I'll handle that for you.
Yes, ma'am. Thank you. Thank you very much. Need all the help I can get. I would just, as per council recommendation, I want to offer on lines 21, striking the word is, and inserting the word shall be. Also on line 35, striking the word is, inserting the words shall be. And on line 44, changing the effective date to July 1, 2010. Are there any objections to those amendments? Are there any objections? Seeing none, they're adopted. Are there any further amendments? Mr. Mangum?
No.
Oh, okay. Any further discussion? Seeing none, on the gentlelady's motion of do pass by substitute on Senate Bill 4, all in favor say aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Senator.
Thank you, members of the committee.
Okay.
The great
Let me suspend for just 1 minute. 1 minute. Thank you. That really was Alan Page calling me. Yeah. Let me call Senate Bill 136, Senator Douglas. Former Representative Douglas, Senator Douglas.
And I am not in your parking place, Mr. Chairman.
No. No.
Governor Chapman was in my parking place the other day, and we dealt with it.
The domino effect.
It was.
Let me just a brief history of time on this bill. We met on this bill in the summer. Then we met again on it early on in the session. I think the sticking point, Representative Abrams, is I don't know if I'd call it a sticking point, but I think the primary issue on this bill was a larger concern on members of the committee in general, including myself, that the bill would not adversely affect the existing memorandum of understanding between the state of Georgia and the federal government, and that we wanted to make sure that we coordinated with pardons and paroles on the language of the bill in order to make that transition between that which we're in now and then requiring us to adhere to that agreement, right, and not basically not giving future administrations the ability to change that, to codify the agreement as opposed to not having it in code. And I can understand the intent behind that. Just want to make sure that process was seamless.
We have done that now. Legislative Council has verified that we are in compliance with the MOU. Pardon and parole, they're here today. They're on board with this, and I think we've punched the tickets, Mr. Chairman.
I agree. That's my sense as well, and I want to thank pardons and paroles personally for their engagement on the issue and for closely coordinating that with Senator Douglas, and I think that helps the bill, that helps the committee have a comfort level on just the seamlessness of that process and crosses the T's and dots the I's, I think. So, having met on it twice before, any questions for from the committee to the author on the new substitute, LC 294068S? After that, I will ask pardons and paroles to chime in to the extent that it wants to, and then we'll march on from there.
I will just reiterate, Mr. Chairman, that this is a voluntary program. There is no mandatory repatriation here.
Ms. Abrams.
Thank you, and thank you, Mr.
Remember
Senator.
what I said before the meeting.
I do, and I'm going to be very sweet.
Thank you. The word was gentle.
I try to stay within the bounds of the law. My question is, with regards to the earlier version and the version that I've just reviewed, there was earlier language that spoke to the rights of the alien deportee with regards to getting access to counsel. I don't see reference to that language here. Was that taken out in order to comply with the MOU?
That's correct.
Okay. And can you speak to, or will pardons and parole be able to speak to what the MOU actually requires in terms of that?
I'll let them speak to that.
Thank you. See, that wasn't so bad.
Thank you.
Ms. Levitas.
Just like to be recognized for motion at the appropriate time.
Okay. Any additional questions for the author from members of the committee? Seeing none. Thank you, Senator. Let me ask the representatives from pardons and paroles to come forward, if they could, to address Representative Abrams' concerns or questions.
Thank you, Mr. Chairman.
Thank you, Mr. Keller.
My name is Bob Keller. I happen to be the Vice Chair of Board of Pardons and Parole. And so that's a great question, and I would love to tell you that I had the exact answer to that, and I don't, and I apologize. But what we did with Senator Douglas's help, we went through and we basically have codified the MOU. And so if it's not in there as a result of that, it is not in there as a result of it not being in the MOU. And I can understand your concern. I just can't tell you how that is handled, from that standpoint.
Mr. Chairman, if I could just add to that.
Sure.
Representative Sallier is going to carry this in the House, and we'll try to get an answer to that before you see it on the floor of the House if it gets that far.
I will get you an answer. In fact, I will come back today with an answer.
Mr. Mangum.
Yeah, it's someone who's really, thank you for bringing this bill, Senator, who we share a delegation together. I'm not really clear on this bill, and my distinguished colleague and I have not talked about this bill, but is the concern that my colleague have about the language when the inmate is given notice, or is there an issue that they may not have counsel that would tell them they're right, that this is voluntary, or is that a concern?
They have to sign. They have to actually sign a form saying that they wish to take part in this program.
Right.
So it's absolutely voluntary.
Right. And basically, the incentive basically is they'll be out of prison, but they'll go back home. But if they stay here, they'll be in jail.
Right. They're not eligible for this until they're actually eligible for parole here in Georgia.
Okay.
They don't get any time off for good behavior or anything like that. So the incentive is that, yes, we'll give them a ticket home, and they can go on back home and take care of their business.
But if they stay here, they may not get parole.
They may not get parole. That's correct.
Okay. All right. Thank you.
I see no further questions. Thank you, gentlemen. We have Mr. D.A. King with the Dustin Inman Society on Senate Bill 136.
Mr. Chairman, in the interest of time, if I may, I'm only grateful to the Senator and Pardons and Paroles for the work. I'm grateful to this committee, and we support due pass.
All right, thank you. All right, I see no one else signed up to speak to Senate Bill 136. What's the pleasure of the committee, Mr. Levitas?
Move to pass the substitute SB 136 LC 294068S. Move to pass.
Move to pass Senate Bill 136 by substitute LC 294068S, second by Representative Mangum. Are there any amendments? Excuse me. Seeing none, any further discussion? Seeing none, on the gentleman's motion of SB 136 do pass by substitute LC 294068S, all in favor say aye. Opposed? No. Let the record reflect 1 no.
Thank you, Mr.
And
Chairman.
the motion is adopted. Thank you, Senator. Let me call Senate Bill 250. Senate Bill 250. This is by Senator Hamrick. I understand Mr. Brian Fortner, on behalf of the Solicitors Association, is going to present the bill on behalf of Senator Hamrick.
Brian Fortner, President of the Solicitor General's Association and the Solicitor for Douglas County. And let me say I appreciate the chair allowing me this bill to still move forward. It's very important to me, and Senator Hamrick could not be here.
Not a problem. Let me ask you, Mr. Fortner, we've seen this bill before.
Yes, sir.
Give us just a snapshot of the problem, refresh our recollection on the problem that the bill addresses, and then on the particular language that we're looking at here and how that will go ahead and address it.
This one is very simple. There currently is a statute on the books regarding the disruption of public schools. A judge in my jurisdiction ruled that the statute, as it stands today, is constitutionally overbroad and that it captures too much conduct. For example, if someone was repeatedly coughing and that became disruptive, that would be captured in the current statute. So specifically, we needed to adopt some language in regards to intent. So we propose knowingly, intentionally, or recklessly, and by adding it to that, it tracks some other disruption statutes, and that would satisfy the judge is ruling and make this statute constitutional. I've talked to other prosecutors about it. It is still currently being prosecuted in some jurisdictions because there are differing opinions, but we felt that this was the best approach to go ahead and clarify the matter and make this constitutional and resolve any questions. And GACTL did not have a problem with this. As far as I know, they are here if they do, but it actually is going to narrow the prosecution to where it's appropriate and not capture that other behavior.
And just to be clear, this has been this is the language endorsed by the Solicitors Association.
That is correct.
Okay. Questions for Mr. Fortner? Seeing none, there's no one signed up to speak. What is the pleasure of the committee? Move to pass by Representative Ramsey of Senate Bill 250 LC 140047, seconded by Representative Levitas. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it, and the motion is adopted. 2, 3, 4, 5, 6. Let's go ahead and vote on that again. All in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Mr. Porter.
Thank you, Mr. Chairman.
Timing is everything. Let me call Senate Bill 6. Senator Jackson.
Thank you very much, Mr. Chairman, and ladies and gentlemen of this committee. Thank you for your kindness in hearing this little simple bill. It's a holdover from last year. It's simply good, as I see it. I hope you'll see the same. What it does, it simply changes the penalty on restricted driver's license. My concern, and the reason I brought it up even last year and hoping to move it on this year, is I had 2 or 3 cases where I felt like that it would be a help, and I think it would be a help to all working people. I had a lady in one of my counties in my district who had a great job at South Carolina Penal Institution and got pulled over for some minor violation and didn't have her glasses on, and they took a license for 6 months, and we couldn't get them back, and she finally had to hire somebody to transfer her backwards and forwards to work for 6 months to save her job. So that's basically what this does. It's a simple, good approach. I think it's good. I hope you'll see the same.
Senator, let me ask you a question. I know we saw the bill last year. The issue that bothered me most about this, and I think you touched on it in your comments, is that right now, if someone has, let's say, and they have to wear eyeglasses, a restriction on their license, right now, that violation occurs, the agency involved in administering, which is DPS, Department of Public Safety, is that correct?
Yes.
It's not DDS, it's DPS. Okay, just want to make sure I'm clear on that. They have the ability to suspend someone's license for 6 months upon one violation of that. What bothered me personally about that is that, you've got a situation like, let's say, the single mother in the Augusta area, forgets to put her glasses on one day, has that violation, and all of a sudden she's lost her license for 6 months. She can't get to her, can't drive, can't get to her job, loses her job, and the question is that the way we want the law to work? I'm troubled by that possibility. I'm also troubled by the possibility that kind of seismic decision on someone's life, because that decision has a domino effect on their life. They could lose their job if they can't drive, depending on the circumstances. That kind of seismic decision is made, if I understand the process correctly, and someone can correct me if I'm wrong, please, is made by someone who is ultimately a member of the executive branch and unaccountable. They're not a judge. They're someone in Department of Public Safety makes that decision upon their discretion and only their discretion. Correct?
Well, I'm not sure where that's quite correct or not. I'm not a lawyer, all y'all are, but it may be my friend's department back here.
Mr. Hammond,
would you help me?
Do you want to address that?
folks who lose it because they don't have their glasses on.
Mm-hmm.
And there's another bill out that talks about people who've had LASIK surgery and forget to get their license changed to take care of that. That's an affirmative defense under a bill that's coming from the Senate, from the House. The other issue, though, in this particular kind of situation is there are a number of reasons that the licenses are suspended or have those restrictions on the back.
Right.
We actually have a case where there was a person who only had the use of their left arm, didn't even have a right arm, that was driving a standard shift automobile.
Right.
So those kind of penalties, vision is fairly easier that we can, as a group, talk about and say that's good. But there are some others out there that aren't.
Understood, and I think you're making a good case maybe for where I'm coming from on it. I think you are, and that is that if you have a violation of a restriction like eyeglasses, what I just heard you say, if I understand you correctly, and please again correct me if I'm wrong, is that once that conviction comes in, that's an automatic suspension of 6 months. And speaking only for myself, members of the committee, potentially for others, I find that to be a little onerous, in that a violation of a restriction is one thing. A violation of a restriction that results in an accident, damages, personal property, whatever it may be, that's another thing. It seems to me to be a very case-by-case scenario, and therefore, rather than having the executive branch, as a matter of custom and practice, suspend that license for 6 months no matter what, do we not do better by the citizens by having a judge decide on a case-by-case basis? Well, this occurred. Here's the result. If there, if a violation of restriction is one thing, a violation of restriction that causes an accident and damages and injuries and so forth is wholly another. Shouldn't those cases be judged on a case-by-case basis?
There is a conviction in the court, wherever it may be, and
Mm-hmm.
the judge makes a decision that they're going to enforce that that's a violation. It comes to us, we're stuck. We don't have any gray area.
So really there's no discretion right now under the law that gives the judge the ability, actually no ability. Once there's a conviction, period, there's a suspension no matter what the circumstances. And the question is, from a policy standpoint here, is are citizens really served well by doing that, and shouldn't a judge be given the ability to take a look at the situation case by case? I know what you're saying, Mr. Tran. I get it. You're doing your job, and you're enforcing the law as it's written, and I'm not taking issue with that. Don't get me wrong. The question for the committee is that the proper path?
And there, as I mentioned, there is a House bill coming, or that passed the House in the Senate rules, I believe, that says that it's an affirmative defense. If you've got the glasses fixed, you have LASIK or whatever, there is an affirmative defense there now, which doesn't exist.
I think that's going to be I think that's a separate issue, because that's a very fact-specific exception, as opposed to giving the judges the discretion that they need in order to judge each case differently. The lady that Senator Jackson talked about, I don't know if there was an accident or not, but she just, all of a sudden she gets rung up for this and loses her license for 6 months. That affects people's lives, and in this day and age, in this economy, somebody losing their job because they didn't put their glasses on, which resulted in no accident, thank goodness. That's right. But didn't, should this lady be losing her job? Well, I don't know, but I know that someone who's accountable to the people in that elected circuit, whether it's Cobb or whether it's the Augusta area, are in the best position to do it, as opposed to someone in the executive branch. That's just my opinion. Mr. Franklin.
Thank you, Mr. Chairman. I am a little concerned when I hear the department say that their hands are tied if there's the conviction, particularly when we see in the existing code that the department may suspend. We've given the department the discretion. We did not say they shall suspend. They have the discretion to look at the facts, as you were stating, and I'm concerned that they're unilaterally heavy-handed, using their discretion to suspend in all cases, and that does concern me. And
it concerns me as well. And Mr. Hammond, I'm not going to sit here and judge the job the department's doing or not doing, and what decisions they're making based on what. I think you just heard a reinforcement of the fact that it's a little disturbing that could be applied in that manner. I think the presumption is that it is being applied in that manner. Again, not taking any issue with the job the department is doing. The question is that really the appropriate avenue? Mr. Levitas.
I guess I come down maybe somewhere in between because it seems to me I understand what the senator's trying to do, and I agree with the intent. We don't want somebody in that situation. On the other hand, and we're not talking about cases of armed robbery, robbery by snatch here. We're talking about driving violations. But the question is there some avenue in between where you have a case like that where somebody is a one-handed driver driving a stick shift? That's not something they ought to be doing. I think we have to give some leeway to the department to be able to do it. And maybe, I don't know whether it's a litany of what the restrictions are or something, but we have to come with something in between. I would think. I don't have an answer.
Don't we do better to have the judge make that decision as well?
I guess
that's why we have these people.
If the judge did, and maybe I missed that part of the discussion, does the judge have the ability, him or herself, to actually suspend the license, or does that have to be done through DDS?
Mr. Chairman, we need to rely on you for that.
The judge tells us whether or not he's going to enforce the ticket and whether or not there's a conviction. Once the conviction comes to us.
But on the sentencing part, in other words, the conviction may come, but in terms of the sentence as to whether or not there's a suspension, whether there's a fine, whatever sentence there may be, once that conviction kicks in, once that conviction kicks in, the suspension goes into effect. Yes. So there's no discretion on the sentencing phase, correct?
If the judge decides to downgrade the ticket to something else, that's right. Get past that problem, that situation.
Oh, yeah, but do we want judges, downgrading tickets in order to do an end run on a violation? That seems to me to be backwards.
Yeah, I certainly don't.
Okay.
That's why we have a penal code.
Mr. Setzler.
Thank you, Mr. Chairman. Can I address a question to a member of the committee?
Sure.
I'm going to pick on Representative Everson. I'm going to, just as a for example. Everson, sorry, Representative Everson. And I ask this question for purposes of illustrating a point. Representative Everson, if you had a choice, if you were given the requirement to choose between, I'm just going to pick on you here, between losing your license for 6 months or paying a $5,000 fine, would you rather pay a $5,000 fine, or would you rather lose your license for 6 months? If those were the only choices you had.
Well, now we're talking about a misdemeanor here, so
I understand. This is a thought picture to make a point.
Okay.
I think a lot of folks in this room would pay $5,000 before they would lose their license for 6 months. And I share that. I make the point to say losing your license is a seismic event in someone's life. I think the chairman's point. I would pay $5,000. I mean, I would be doing a lot of honeydews to make up for that. But I'd be paying $5,000 before I lost my license for 6 months, because the lives most of us live. I think we need to view this in the context of other folks who have lives that are just as complicated and as busy as our own. And losing a license to me is a big deal. It's not a felony, but it's an awful big deal, Mr. Chairman. That's all I've got.
Ms. Abrams.
I actually have a couple of questions as to the legal structure of the bill. Under current law, the department, it says the department may suspend the license upon receiving satisfactory evidence. So I'm confused by the assertion by the department that they don't have discretion, because it's upon receiving the conviction, the language of the law says that they may suspend the license. It does not say that they shall suspend the license. And so to the questions that have been raised, I'm not certain why they don't enjoy the discretion that they're seeking to gain now. My second question is in order to solve the problem that Senator Jackson has raised, I'm not certain how lines 11, 12, and 13 actually accomplish that, because what that does is remove...
Are you looking at the original bill or the substitute?
I'm looking at the substitute.
Okay.
LC 294325S.
Let me back up on a second on you, and I apologize for interrupting, but I'll certainly go back.
Absolutely.
This substitute was given the late hour last night and some late communication that, frankly, I've not been able to see it. The intent of the substitute, just so it's clear, is to where we were attempting to go, was to simply have a situation where we had this violation. It remains as a misdemeanor, just like any other traffic offense, not a civil penalty, but it gives the sentencing as to whether or not there's a suspension, a fine, whatever, solely in the hands of the judge. I don't know, candidly, if this substitute actually does that or not, because I have not been able to review it really carefully, and Ms. Travis, who drew it up, isn't here, so there's a logistical problem there that will solve Senator Jackson sooner rather than later. But to the lady's point before, your point in the original, the way the law is structured right now, I don't have the original bill, which has the existing language, but as I recall, I hear you loud and clear on the discretion that officially occurs now. But you're making the point that Mr. Franklin made a minute ago, but we just heard DDS say that a conviction comes and DDS goes ahead and and implements the suspension as a matter of custom and practice. So as a practical reality right now, that discretion is not being exercised for whatever reason. I'm not taking issue with DDS. This is not the time or place, for that. The question is, how are the citizens best served in that situation? By having the executive branch go ahead and administer this from a sentencing standpoint in practical terms, or to have a judge take a look at it in terms of whatever fine may come down the pike, whatever suspension may come down the pike, in that elected, accountable judge's discretion. And I apologize. I just want to give you some broad context logistically on the sub and on the substance. So I yield back.
I appreciate that. So that leads into my second question, because I am uncertain as to how the stricken language strikes me as being a fail. Assuming what we're attempting to achieve is not currently being achieved, I think that is departmental. It is not legal. And then in terms of the proposed language, I'm not certain how this proposed language actually accomplishes the ends to which we're seeking to achieve, because part of my challenge is that this also would not allow for emergency situations. Let's assume that I'm taking care of someone and I happen not to have my glasses, but there's an emergency situation and I need to operate my vehicle. This allows for no discretion at all. And so I'm not certain how these two pieces interact and what the legal remedy would be.
And we, from a drafting standpoint, we will confirm that. And again, it's just the logistics of last night into this morning. Right now, and having talked with a state court judge in Cobb County about it, my secondhand understanding, to be confirmed by counsel at the appropriate time, is that right now that is a traffic misdemeanor, like any other. The question, so from a how we treat it under the law, it is right now a traffic misdemeanor like any other. The question really is, does the substitute, and again I'd have to confirm that with counsel admittedly, does the substitute provide the avenue to give the judge the latitude, the discretion they need in order to go ahead and hand out sentence? Your question before about emergency situation, that's exactly why a judge ought to be making that decision. It's exactly why, and I appreciate the lady making the point.
Thank you.
Yes, ma'am. Mr. Everson.
No, mistake, drive on.
Okay. A little pun. Very good. Mr. Mangum, did you have something? No. Okay.
Mr. Chairman, could I address the committee?
Yes, Senator, thank you. And we appreciate your patience, but it's important for us to hash that out in our
thank you very much.
Collective understanding.
That's what's good about this process, that we hash it out, and I've heard some good things around the table. So, but I'm here to help people, and this is a help people bill. This violation, this penalty is too strong for a violation so weak. But however you can do it to make it work. I've had 3 of these cases since I got started with this, and they're debilitating to people who are good people and want to go to work and make a living and can't get there. Some of them, in 2 of the cases, they were single people. They didn't have family to move them. And the girl that I'm talking about had a job with the penal system would have lost her job, a good job, had she not been able to hire, maybe spend that $5,000 that my friend talked about. So help me with this and get it out of here, and I'm open-minded to the things that you all know that'll work. Your discretion of the judge seems good to me. That is an avenue of relief, maybe. But this way, there is no relief. You just didn't have your glasses on, and I can see from here to DeKalb County without them. But it wouldn't hurt me a bit.
Or at least you say you can.
But yeah, okay, Cobb County, maybe. All right. Really. But if I didn't have them on, I'd be penalized, and
sure.
Penalized too severely.
And the penalty is important because the state has a rational interest in making sure that when you go ahead and employ the privilege of driving, that you can do so in a responsible manner, because it is inherently a dangerous instrumentality.
It would take many times.
We all understand that. The question is the punishment fitting the particular crime in that circumstance?
That's right.
I agree with you 100%. This is a people bill, and that the punishment, the practical punishment standpoint, has got to go ahead and fit the violation. Who's in the best position to do that? Us? No. A judge? Right. Yes, just in my opinion. What I'm going to do, Senator Jackson, is, and I'm not going to put this on Mr. Bundrick, that would be inherently unfair. I just want to make sure, to go to Ms. Abrams' point of earlier, I just want to make sure that the substitute we're putting forward actually does what I think it does. I'd rather take an extra day and get that right, and we'll come back in the next meeting. I think there's a broad-based support for where you're going on this. I just want to make sure the drafting is right. Mr. Levitas.
I hate to make it even more complicated.
That's
but
all right.
Quite frankly, what I'd like to see is not have to reach to give to the officer some discretion within the code that says, that follows up on what Ms. Abrams said, if in the opinion of the officer this is an exigent circumstance, it's not a violation, because I think that the officer is going to be bound by the letter of the law to write the ticket, and then you have to go to court and say, well, here's the situation. So while we're redrafting, I'd like to visit some leeway in the code for the officer to have some discretion.
Speaking only for myself, I think that's an excellent idea that the committee ought to go ahead and consider. Give the officer some common sense discretion on an exigent circumstance. Give the judge the discretion and latitude to do what he or she thinks is right under the circumstances. Is it just a violation of the restriction? Was there an accident? Did somebody get hurt? What are the consequences? And that's where you get into your graduated level of punishment. And that's exactly why we have the system that we do. So I appreciate the suggestion.
Thank you for your kindness. I just want to say as I leave, I believe sincerely government should be a friend of people if they can. And this is a case that government.
Wouldn't that be something?
Yeah, that would. But thank you so much for your
kindness. Thank you, Senator. We'll get it right. We'll get it right.
Thank you.
Thank you, sir. Representative Levitas, did you want to?
Yeah, that's fine.
Okay. And if not, I want you to be comfortable.
Yeah, we're fine.
All right. Senator Staten is, I believe, chairing a meeting this morning, and so he could not be here for Senate Bill 59. Representative Levitas has graciously volunteered to carry the burden on that, so I'll recognize him to speak to the bill. We did see this before last year. Just to refresh your recollection, that bill, Senate Bill 59, did have a companion tacked onto it. I think it was one of Representative Chairman Willard's bills. That's come off. We'll go ahead and focus on the language that we focused on last year, which you may recall, Representative Levitas.
Thank you, Mr. Chairman. I wanted just to add to that there was an issue involving telephone books. I don't really remember what it was, but Representative Willard, or Chairman Willard, has told Chairman Staten that issue for him has been resolved, and so he has his only purpose was using it as a vehicle, and that issue's been resolved. So it's, he's fine with going back to the original Senate language. And I have had distributed for you, just as a little bit of a memory refresher, the Senate Research Office summary. Long and short of what the bill's trying to do overall is update Georgia's law regarding electronic mail fraud, and specifically adding provisions and penalties for those who falsify headers or misrepresent their true identities.
Can I interrupt you for 1 second? I apologize. I just want to make sure, Mr. Lafayette, I could ask you or Ms. Morris, the version of SB 59 that came out of committee last year, I'm going to presume that was a committee sub at the time. I'm looking at my file in the original.
The original, and that's the intent is to go back to the original bill. The sub was the part that included Chairman Willard's, and that's why we're going back to the original bill.
Okay, but were there any changes in this to the 59 portion of the sub? In other words, any changes that we made in 59 in the sub, those are. Would those be included here or no?
The truthful answer is I'm unaware of any changes that we made, and so I can't speak to that.
Okay. I just want to make sure that we're looking. Okay. And when we came out 59, I understand the Willard language is out, but were any changes within the actual language of 59?
Yes, and I'm printing an amendment that the senator said he would like to go ahead and include. There were some changes as far as who has the power, and it's specifically less Attorney General Diaz and so forth. And I'll have that amendment shortly.
Okay, in the interim, let's go ahead, and I apologize for the interruption. We'll make sure that we're looking at what we're supposed to be looking at.
It's certainly not a problem. Thank you, Mr. Chairman. We certainly want to pass out the right version of this bill. If you look at the Senate summary, it gives you, there are actually about 7 different ways to violate this particular statute, and it has to do with automatic email address generators. It has to do with taking information from a website where they've said we won't use your information for any other purposes. And these are the kind of emails where they're trying to make them seem like they're somebody else, or to make it difficult for you to trace back to the original sender of the email. And this is one of those transparency issues, and basically to keep spam out of your junk box, and even worse in the case where people actually lose money. And what you will see is that there are several different, as I said, methods for violating, whether it's using multiple email accounts, whether it's using those mass generators I described. And then there is actually in lines 76 to 83, and then again 84 to 90, if you violate the provisions 1 through 5, knowing certain things, like I said, is if this was from a website where they said they wouldn't pass on the information, those are a separate set of penalties. If you move on to the bottom, line 87, that's where you begin with the punishment phases, and I actually misspoke. It's line 76 through 83, and then 84 through 86 are the ways to have violations of 1 through 5 with these additional provisions in it. And then the sentencing provisions are multiple ones, and you will see that there is the actual punishment under subsection C goes all the way up to 7 different ways to violate the provision. They have different penalties. There are penalties for the number of emails that you've generated. If you use, for example, in C2, lines 91 through 96, if you use 250 commercial email messages during a 24-hour period or 2,500 commercial email messages in a 30-day period, it's a 1 to 5 felony. Things of note, and you can just see as you go through this that for the different violations, it's anywhere from 1 to 3, 1 to 5. If you've actually been convicted of this offense before, that was a violation of either a state or federal law, this is on C6, lines 112 through 117, then the penalty can be up to 10 years and up to a $25,000 fine. And I will point this out for no other reasons. I don't think it has any effect on the statute itself, but going all the way back to line 60, I will tell you I'm not sure if we actually need the word conspire to or. Line 60 says that no person shall conspire to or knowingly. There may be a reason for that, so I'm not suggesting we exclude it, but line 60 on page 2, the last line on the page, when it talks about the violation, it says no person shall conspire to or knowingly. My understanding from law, and Mr. Moss I see is here, he may have a comment on it, the conspiracy would be covered in the law as a general matter of criminal law. I don't think it, my only concern is I don't think it would have any effect on the law. And I just asked Mr. Moss, would it make any difference one way or the other whether we include that language, conspire to or? Okay. So I would just say in the interest of respecting the author, I'd like to leave it in. I don't think it will have any serious, any effect on the law, but I just wanted to point that out in case it was a... Well, and so that may be the reason he included. He didn't want it reduced. So as I said, so maybe that's the reason. Let's go ahead and leave it in. So he's punishing conspiracy, which would normally be punished by up to half. In this case, you would be punishable to the full extent of the law. There's also, again, just to refresh the committee's recollection, the D also provides, subsection D, beginning on lines 121 on page 4, provides that forfeiture provisions that if you earn any money from the proceeds of the sale from this, that money can be confiscated, as well as the software. And as I look at this, I'm looking at it looks like that has been removed last year by the committee, and I'm guessing that was another Franklin's Abrams amendment, if I'm not mistaken. So what we did last year, and what I would be suggesting that we do this year, since the author seems to be okay with it, is 121 through 128 would be stricken and replaced simply with the Attorney General, a district attorney, or an assistant district attorney may enforce criminal violations of this code section. And does everybody have a copy of what Mary Lou handed out?
Everybody has the amendment.
Right. And then section E changes as well. That is on line, that subsection E begins on line 129 of the bill, and we apparently changed that last year, and I would be moving, once the committee has an opportunity to review that, that we include, that I will be making a motion to amend lines 121 through 140 and replace them with the printed material that you have in front of you. And with that, Mr. Chairman, I would take any questions the committee might have.
Ms. Benfield.
Yeah, I just have a general question. How does this interact with federal law? Because if emails are sent from one state to another, at that point, the federal code that's cited, I guess 18 U.S.C.S. Section 1037, would kick in. So does this only apply where emails are sent and received within the state of Georgia?
It applies. If you look on line 54, that's on page 2, number 10, under the definition, this applies to protected computers and specifically refers to them that the computer was located within the geographic boundaries of the state of Georgia. So it would only reach where the emails have reached an email in Georgia. Now, the state and the federal, as you know, Ms. Benfield, are concurrent jurisdictions, so you could punish them federally if they so choose, and you could also punish them at the state level for the same offense since there's two different sovereigns. But this bill specifically deals with the Georgia recipient, and we couldn't, of course, go out into Alabama and try and reach the offender out there.
Okay, so I want to make sure I understand this. If either end of if you're either receiving or sending from a computer in Georgia, then Georgia could have jurisdiction over those cases?
Georgia would have jurisdiction over, my understanding is, would only have jurisdiction over the receipt of those within the state of Georgia, because this talks about use a protected computer. If you use a Georgia computer to either generate the emails or if it's received by a Georgia computer, then you would be subject to this offense.
Okay, so you could be either on the sending or the receiving end,
right.
And
in fact,
be subject.
If you look at lines 61 through 63, it says use a protected computer of another to relay or retransmit multiple commercial email messages with the intent to deceive or mislead. So then in that case, you could be tapping in from Alabama to a Georgia computer and using it somewhere else. But again, I mean, you still have the same jurisdiction problems. If someone's in Alabama, they never come to Georgia, you wouldn't be able to get them. The feds could get them. We couldn't get them. But if they were to enter Georgia, they would have violated the statute and be subject to the jurisdiction of the court.
Can I ask one more follow-up as far as the concurrent jurisdiction? What are the double jeopardy issues involved here? I mean,
there are
could
none.
you have simultaneous? Well, how is there not double jeopardy? Could there be a federal and a state prosecution?
Yes, for the same offense.
And how do you avoid
sovereigns.
double jeopardy?
It's not double jeopardy because they're different sovereigns. There's a federal sovereign, and there's, notwithstanding Representative Franklin's disdain to my right, there's a federal sovereign and then there's a state sovereign. And so both of those have jurisdiction, and you can actually be prosecuted for the same offense, both federally and locally. Now, the reality is that the feds don't often have the resources to go all over the country and prosecute this. So the reason for having a statute that here in the state is so that the district attorney, so the attorney general can help protect Georgia citizens if the feds can't reach or choose not to reach that crime.
Because we have the resources to go all over the country and
no, we don't. That's just the point. That's just the point. So we're focusing on Georgia here.
Okay, thank you.
Ms. Abrams.
Actually, Mr. Levitas covered it. I did want to reference the changes that were made last year, but those have been brought forward.
Any further questions for the author, for the sponsor? Seeing none. 59. I see no one sign up to speak on Senate Bill 59. Ms. Abrams? I'll recognize you just for a moment. We're going to be at ease for just a few minutes. Just one concern to take up with the author before going to a motion, just out of an abundance of caution. So we'll be at ease for just a few minutes. We were considering Senate Bill 59, authored by Senator State, and Representative Levitas was. Representative Levitas presented that. We had one question, one issue to resolve. I think that's been resolved. Just out of an abundance of caution, Representative Abrams had a motion, I believe. Representative Abrams.
Move to pass. LC 2944. Sorry, LC 284482.
Move due pass of
Sneaky
Senate Bill
statement.
59 LC 284482. Is there a second? Second by Mr. Everson. Are there any amendments, Mr. Levitas?
Mr. Chairman, I would move that in lieu of lines 121 through 139 of the bill, that we insert the pre-printed language that has been distributed to the committee in lieu thereof.
All right. So just to make sure Mr. Bundrick is clear. Mr. Bundrick, are you clear on the structure? Okay.
Let me amend my motion a little bit. I am not including Section 4, Section 5 on page 2 in that amendment, just the quoted underlined language.
Okay.
No, we're just not including this.
Page 1 of the amendment plus what is described
Plus
as
number-
Section 4.
Paragraph 4, right.
Paragraph 4, excuse me, on the second page of the amendment, but not what's labeled as Section 4 and Section 5
Correct.
of the amendment. Okay. Is there any objection to the amendment? Is there any objection to the amendment? Seeing none.
I can give Chairman Smith a red badge, have him step up to the table.
Hey, whatever it takes. Are there any further amendments, Ms. Benfield?
I just have a quick clarification on Section 4 of the amendment. Do we need any clarifying language about and shall apply to all acts committed on or after that date?
You talk about Section 4 on page 2?
Of the amendment.
Yeah, we're not including Section 4, Section 5.
Okay, I'm sorry. Okay. Well, is there clarification in the
Well,
original bill?
the way it works is my understanding, and Council Bundrick can help me, but if you don't have an effective date in the bill, it's whenever the governor signs it, or if it goes into effect without his signature. And we've already got in the bill.
Well, if there's no effective date on the bill, it's July 1.
Yeah.
July 1, right. So I'm saying...
Right, for a general bill.
Do we need any clarification about shall apply to all acts committed after July 1st?
I mean, I wouldn't think that we do.
Is that implicit by virtue of the effective
Because it would
date?
be a retroactive act otherwise.
Yeah.
Okay.
Okay. Mr. Thompson.
Mr. Chairman, I'm just confused as to what we're doing on the amendment. On page 2 at the top of the amendment, it says 4, but I thought we were stopping at 139, and then we have another.
I'm
4.
sorry. Well, it should be 140. If I misspoke, I need to restate that through
Let's go ahead and
140.
restate that for Mr. Bundrick and members,
Right.
just to be clear.
So, again, I apologize to members of the
That's all
committee.
right.
So what we would be doing is replacing, beginning on line 121, all the way through 140 on page 5, and replacing with the printed material.
All right, and then F on 141 is staying.
And that is staying,
Okay,
correct.
Thank you.
Yeah. We're at the due pass.
Are there any further amendments? Seeing none, any further discussion? Seeing none on the gentlelady's motion of due pass SB 59 by substitute. It'll be by substitute. All in favor of the motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, members. I believe that concludes the full committee meeting. I know Mr. Setzler wanted to have a meeting of his subcommittee on Senate Bill 112 and on Senate Bill 299. And so those on that subcommittee, please hang around for that. I know he wanted to get going on that right away, and we'll do our best to make that happen. Thank you.